Laura Edmonds, present.
John Mahoney, present.
Cynthia Dell, present.
Becky Walsh, present.
Luke Tashin, present.
Rich Garrity, present.
The only one missing right now is Jessica Cardone. And so we're here tonight for our training session. So I'll turn it over to Town Attorneys Ira Bloom and Pete Gelderman. If anyone needs the handouts, they're posted on the website. If you need to reference them, we can also pop them up on the screen if you need to reference them. But I think the preference is to have a virtual conversation with everyone. So it's more like a training session. The floor is yours, Ira, Pete.
Okay. Should I start, Pete?
Sure.
Well, good evening, everybody. My name is Ira Bloom. Pete Gelderman is here. I haven't had the pleasure of meeting, I think, most of you on the ZBA. I think you probably know Pete. He's been covering some of your meetings in recent times, so I'm glad to have a chance to sort of meet you this way through Zoom. We're going to go through some basic topics and maybe some advanced topics too, in terms of your role as members of the Zoning Board of Appeals. You have copies of an outline that we have prepared and a copy of a couple of cases that are sort of pivotal to your understanding of what it means to be on a Zoning Board of Appeals, and we'll cover that. The format is fairly loose. I'm going to go through some sort of preliminary topics on the outline, and then we'll get maybe to the heart of this in terms of how we define hardship, and then we'll talk about some alternative approach to granting of a variance, and we'll talk about the two recent cases, fairly recent cases now, and how that all fits together. Should take roughly an hour. We've done it before in an hour, and we have plenty of time tonight, so we can certainly go past that if you need it. It's fine if you have questions. Just kind of wave your hand or just sort of interrupt, and we'll be happy to answer a question. During the presentation, it's a small enough group we can do that without, I think, getting thrown off too much. Although it's important that we try to get through all this, so we should be able to do all of that. So let me just start, and I'm following basically the outline that hopefully you've had a chance to look at. Just some preliminary topics here, which go along with really any land use board, but we're talking about your ZBA tonight. It's important for that too. The concept of notice, we start with that. We are very careful about notice because if proper legal notice is not given, then basically there is going to be a jurisdictional defect in what you're doing. So that's why, in working with Lynn, we try to make sure, she tries to make sure, and we try to help to make sure that proper notice is given for all matters, so we don't have that defect and waste our time and have to do it over or cancel the meeting, things of that nature. Participation, it goes without saying that your presence at these meetings is very important. If you do have a reason to not attend, and that happens, of course, then best thing is to notify the chair and notify Lynn, and then alternate arrangements can be made. There's sort of a place mark here for hybrid meetings and remote meetings. That's been a hot topic. That's why we're dealing with remote right here, and that's really a subject for a separate session, which we can do at some point. And we have some memos that I think we've provided to Lynn. I hope, if not, we'll get them out. It started out as a series of executive orders from Governor Lamont. It's now sort of merged into some statutory authorizations, which encompass a number of executive orders. And so we have this concept of remote meetings or hybrid meetings, and I'm not going to focus on that too much tonight unless you have particular questions. As I say, that could be a full night's review. Time requirements, again, this is important to keep in mind. Basically, there are 65 days from receipt of an application to commence the hearing, to start the hearing. Then you have 35 days to complete the hearing, and then another 65 days to render a decision. And those last 65 days, that's the work session I heard you folks, a couple of you talking about earlier before we officially started. But that's when you deliberate. Sometimes it's called work session, sometimes it's called deliberation session, but that's when you're meeting in public to make a decision on an application. And it's a public meeting, of course, but people cannot participate. The hearing's closed at that point. It's kind of rare, I think, for a ZBA to take that long to make a decision. It could happen, happens once in a while, but usually decisions are quicker than that, in my observation. You can get extensions granted from the applicant, and sometimes that's necessary also for scheduling purposes. Let's talk about conflict of interest, because this really applies across the whole spectrum of land use boards and commissions. There are statutes which govern members of land use boards, and there's a whole body of case law also which also govern when there's a conflict or not. We basically look for personal or financial conflicts. That's what the statutes talk about. That's what most of the cases talk about. Those can be broadly interpreted. And there's a body of law which has developed. Talk about that in just a second. Under the statutes, which are outlined in the materials, none of you should appear before, certainly not before the ZBA representing another person, nor should you really appear before any land use board representing another person. It raises an interesting problem of what if you need a variance for your own home? You do have a right to seek a variance for your own home. So you would just have to do that, or in some cases, maybe just to create a little separation, have your spouse do it if possible. Some people choose to hire a lawyer. Well, a lot of people choose to hire a lawyer. That's another option, but you certainly have a right to seek relief from the ZBA, even for your own personal property. But you shouldn't represent someone else. That's forbidden by the statute. So when we talk about personal or financial conflicts, I mean, some of this is just common sense. If it's somebody who's appearing before you, that you have to look at the relationship. Is it a business partner? Are you in business with that person? Well, if you are, then that's clearly a conflict and you would have to recuse yourself. If it's just someone you know from town, that is on the other side of the spectrum, and that's not typically enough to cause you to recuse yourself, unless it's someone that you have a close personal friendship. Your best friends, you go out to dinner together, you've been to each other's homes frequently, perhaps even occasionally, then it might be a personal interest. So you have to judge it really. Obviously, in smallish towns like New Canaan, you're going to know a lot of people. So the fact that you know somebody, the fact that you've gone to a restaurant and you happen to know the owner, is not typically enough, in my view, to have you recuse yourself. If you say to me, on the other hand, that it's a regular Friday night thing, that you go every Friday night to this particular establishment, well, maybe then that crosses the line and there's a little more of a personal relationship, and maybe you'd want to recuse yourself. It really depends. Certainly, Pete and I are here to give you our thoughts if those questions come up, and we do that fairly often. We get a call, what do you think of this? We can't tell you what to do. In fact, really nobody can tell you what to do, but we can give you our thoughts if you ever need that. Bear in mind that if you make the wrong decision and you sit through a hearing, you could jeopardize the decision of the board. So you want to make the right decision, and you want to err on the side of not having a conflict. Keep in mind that it's not always actual conflict, but it's the appearance of conflict. So if somebody outside can reasonably conclude that it looks like a conflict for one reason or another, even if you feel there actually is not, then under the law, that's equally objectionable, and you probably should recuse yourself if there's an appearance of conflict also. So that's quickly the issue of conflict of interest, bias, and predetermination. I don't see this quite as often with zoning boards of appeal, but it certainly can happen. You see it more with perhaps with planning and zoning commissions, but it applies equally. And predetermination is when you've made up your mind about something in advance, and you're not listening to all the evidence and reviewing everything. It could happen certainly in a ZBA context. So you want to come into these things with an open mind and apply the law, listen to what you hear, see what's in the record. You certainly do not want to go onto any social media and express any position on anything that has come or is coming before your board or may come before your board. Social media is not a good idea for members of land use commissions. In my view, it can only cause legal issues. Sometimes it's hard to control people though, and they do it anyways, but you do have to be careful about expressing particular points of view on Facebook or whatever form of social media. Bias is not the same as predetermination, and bias is when you really just have expressed some hostility against somebody in advance, or even at the hearing. I suppose it could happen, and that's obviously something you want to avoid. And it sometimes comes out again through postings. In the old days, people would write letters to the editor. There's not too much opportunity to do that nowadays. So it's postings on social media which can cause the problem. Not a good idea. It's the bottom line on that. Keep in mind that any documents that go into the public file or anything you submit are public documents. So people can and do go and look for them and see them, and they're allowed to find them and get them under Freedom of Information Act, FOIA. So just keep that in mind. If you put comments in, those will be public either. Also, there's a whole section here which we probably won't be able to get to for time reasons tonight, but that has to do, speaking of FOIA, with what kind of communications can you have between yourselves. And you have to be basically very careful. Anyone who sends out an email, for instance, to one of your colleagues on the board, if you get a response back, or if you ask for a response, then you have created a meeting under the Freedom of Information Act. That's what they say. So it's the communication and then the response back which creates the meeting. So therefore, you really should basically avoid doing that. The same thing is with telephone conversations, but with emails, it's easier to prove a violation of the Freedom of Information Act. So the safe course is not to send out anything dealing with an application by email. You should just save your discussion for the hearing room, so to speak, or the Zoom room, whatever we're calling it now. So everybody can hear it, everybody on the board, applicant, others who may be listening, and avoid emails, basically. Administrative emails are fine, where, the meeting is 6 o'clock next Monday, that kind of thing is perfectly fine.
I think Luke had a question.
Oh, I'm sorry, yeah.
So my question is, say Lynn sends out an email. Some people do reply to all. I never do reply to all, just 'cause I don't know the answer to this question. But if someone does a reply to all, is that a meeting?
I'm sorry, I broke up a little bit. Look, if somebody replies to all,
Yeah, like tonight, I think most people just reply to Lynn individually, but sometimes someone does reply to all.
well,
You know, saying they're gonna attend the meeting. Is that?
Yeah, no,
meeting
not
night?
the administrative stuff is not. You don't have to worry about that. If the question is, are you all coming tonight at 6 o'clock? And she wants to hear, and you reply, well, that's not a substantive conversation. So you can do that kind of stuff. But if
So it
one
has
of
to
you
be
write,
substantive.
sorry, say it.
So the question is whether or not it's substantive.
Well, yeah, otherwise you can do it. Sure. You can use emails to set up meetings and things like that. But if somebody, were to send an email saying, with regard to the Smith application for a variance that we heard last week, I think so-and-so, I think we should grant it for these reasons. What do you think? And then everybody starts responding. Well, that's a no-no. That's a meeting. Can't do that.
Ira, just before we move off this point, what if, we've had our normal meetings and one of us happens to have an article that's germane to a past discussion. Matter's been resolved, it doesn't involve a current matter in front of us, but wants to share that article with another member of the board. How is that to be handled?
Yeah, well, okay, so if I'm understanding, there's no pending application, there's no upcoming application, it's just kind of at that point in time, it's just for everyone's knowledge, basically, and there's something interesting to read. That you can do. I mean, I think you send that to Lynn and you say, here's an interesting article that, may be of interest to everyone else. Could you send it to everybody? And yeah, there's no application to which it would apply. You got to be sure of that, but if I think that's okay. That's just kind of informational. Here's an interesting article kind of thing. But I'd be careful if it has any link to any application, then you do have to be careful. I mean, there are ways to do that. If the application is still open and it's going to continue to the next meeting, I suppose under limited controlled circumstances, it could become part of the record, I guess. But that's a little iffy too. But if it's totally unrelated, I think you can do that. Emphasis on totally unrelated.
And the best approach, John, is to send everything to Lynn, and then Lynn can forward to other members of the board rather than have, I mean, again, as Ira said, it's not really an issue, but it's just a better practice is to send everything through Lynn.
Okay, thank you.
Okay, let's see if there's anything here. There's a section on site visits. I mean, do you folks kind of do your own individual sort of drive-by site visits like a lot of ZBAs do? You have your list and you just kind of drive by at your own convenience, or do you go out as a group to visit sites? Because I find that most ZBAs kind of do it the first way. They'll drive by a house. One of you you'll just be driving alone, and you just go and say, I got to check this house. I'll check that house. Is that how you do it, or do you do it as a group?
Yes, we typically do it on our own.
Yeah. So it's not quite the same. Planning and zoning commissions often do it as a group, and we have to notice that that's a meeting. It's a public meeting. People can come if you're doing your own individual drive-by. It's not the same standard. So that's okay. I always think it's kind of still a little tricky. If you're just going to literally drive by or stop in front of the house and take a look from the street, no problem. I'd be careful about walking onto anyone's property, without permission, but I doubt if you do that.
Well,
Ira, that
Or do you?
was
We
my
do it.
question. We always do that.
We always do that.
The property owner probably knows in advance then, right?
No.
That you're coming?
No.
Or generally, no?
I think, Lynn, in general, do they know that we're coming? Because sometimes they are surprised, but
Yeah.
I mean, I've never had a problem, but maybe we can make that more of a practice that they know that we're to anticipate board members coming.
Yeah. I mean, Lynn, I just think in today's world, I mean, I would tell the people, you may see five strange looking people walking individually along your property and, don't call the police or anything. They're part of the town government or something along those lines.
Yeah, they generally know. I think sometimes some of the owners forget because the time between the contact and and the public hearing is not one day away. But when they say and we do tell them.
Okay. Yeah. Well, all right. It just try to be careful. I'm just crazy things happen.
Just one point, Ira. If you do go to a property, be careful not to have any communication with the property owner. You're there to, other than maybe I'm just going to look around or, here I am, but don't, that's not a place to have any discussion with the property owner who is an applicant coming before you at that point in time. So it's really just for your own edification, and make sure 3 of you don't go together, because then you have a quorum and then it is a meeting.
Yeah, I mean, those are key points on the first one. The reason is that if one person hears it, then the others don't hear it necessarily. And then one person has some information that the others don't have, and the public doesn't hear it, or anyone opposing it doesn't hear it. So that's not to have any discussion.
I thought you couldn't have 2 people there at the same time.
But you can't, a quorum is 3 of the ZBA, although the ZBA can't take any action with 3 people, but it's a quorum that constitutes a meeting.
So it's okay if 2 people went at the same time?
Well, it's better not to have 2 people without a meeting, because again, the tendency would be to discuss things. And the idea is that the application is discussed in public. So the better practice is to have one go on your own individually, and then nobody can accuse anybody of receiving evidence or discussing the application outside of the public hearing or the deliberation, which are really the only times the application should be discussed among the members.
I'm going to kind of skip around on some things because I want to get to the heart of this within a few minutes. There's a section we have here on ex parte communications, one person type communications, and you should not be discussing applications with anybody except with each other during the public hearing. So you shouldn't obviously be making calls to the applicant or really to anybody. So the idea is that everything be done in public. Everybody hears what's being said. Nobody has any special knowledge, things of that nature.
Can I ask a question?
Sure.
I'm sure this happened to some of the other board members, but people that, may have recognized my name from just the, knowing that I'm on the board. I do get phone calls sometimes about, it's more of process, but, and they tend to be looking for information or, what should I do? How should I handle that?
Well, if they're calling process, if it's like, where's the meeting or how do I, what time is it or whatever. I think that's innocent enough. The problem is that it could relate, then it goes on to other less innocent questions about.
They try to, definitely it moves trying to get information about.
Yeah.
Do you know what I'm saying? I mean, I'm sure it's innocent enough on their part, but they're just trying to get
more
information.
Yeah, or influence you. I mean, the safe thing is probably to say, look, if you call Lynn at the office and she'll give you all the information, you can look at the application online. Any information, she's the best one to contact, and maybe just put them off that way so it doesn't lead to something. And similarly, you might get emails. This comes up too. Emails just get sent to you, and you don't know. You open it, you read it. If it's about a pending application, then the best thing is make sure that it gets sent to Lynn so that it goes into the record and everyone else on the board gets a copy of it. and she will take care of that. So everyone's reading the same thing. And it's also made part of the public file for anybody that wants to comment on it. If it's after the hearing is closed, then in theory, you shouldn't be looking at it at all. And I understand it may be hard to tell. But if you can tell that it's on a particular application which is closed, I would not open it and I would not read it. Okay, I mean, basics, you know that you need 4 votes to overturn or reverse the order of the CEO. You need 4 votes to grant a variance. So those are some simple things. Executive sessions can be held, and I think you might have had some in recent times, and it's usually, I think in your case, to talk about a matter which is on appeal. So you're talking about pending litigation. Again, under freedom of information, they specify just limited numbers of topics which can be discussed in executive session. And I think the primary one for a ZBA would be pending litigation. Somebody has appealed one of your decisions, and you want to get together to discuss whether either get an update on the status or decide perhaps whether there's a settlement option which you want to explore. So that's what that's generally why you would have an executive session. So I'm going to stop now, and I think we'll go to the concept of variance. We'll talk about hardship, and we'll get to the 2 cases we highlighted, Virillo and ENF. And then we're going to talk a little bit more about a separate, independent method for granting variances, which is reduction of non-conformities. We don't have quite as much material here, but we can talk about it. So I'll let Pete pick it up from here, and I'll just chime in as needed too.
Okay, so hardship, which is probably the most difficult concept that the board has to deal with, because under the law in Connecticut, in order to grant a variance, a hardship has to be present. So what is a hardship? And that's been a topic of discussion for years. And in fact, the law has changed a little bit with respect to that through the ENF case that I sent to you. Up until, we'll talk about ENF first. ENF is a Supreme Court case, and hopefully all of you will have a chance at some point, if you haven't already, to read both the ENF and the Virillo case. The Virillo case is an appellate court case. It's very long. It's very detailed. It sort of gives an overview of variance law and hardship and things of that nature. It was the appellate court decided in 2015 that it was time to sort of send everybody back to school with what constitutes a hardship and when variances should be granted. So it drafted this 60-page opinion that sort of does that. And then shortly after Virillo, ENF was decided by the Supreme Court of Connecticut. And what ENF did was overrule a case that had historically been the case that people relied on to determine whether a variance should be granted. That was called the Stillman case. In the Stillman case, a woman wanted to expand her residence. One side of her house was septic, wetlands. Sometimes it could be ledge, but in this case, septic and wetland issues on one side of her house. So she didn't have the physical ability to expand in that direction. Expanding in the other direction brought her into a setback. And so the argument was the peculiar conditions of my property are such that I need a variance because I can't expand anywhere but within a setback area. So the Supreme Court said that was a valid basis for the grant of a variance. And that was sort of the standard that was used for years. And then ENF came along, and ENF said, no, that's not the standard anymore. Stillman was specifically overruled by ENF, and ENF created a much more difficult standard for applicants to meet to get a variance. And essentially, it brought in economic factors into the discussion so that when if a property can be used in a manner that's consistent with the zoning regulations, in a way that leaves the property with economic value, a variance essentially should not be granted. So if someone, for example, had wished to expand their house, go back to the same fact pattern that we had in Stillman, someone comes in for a variance after ENF with the same issues, the court is going to say, well, the house has economic value. It's in a residential zone. You have a house that works. It has economic value. You shouldn't get a variance based on the fact that you don't need to expand the house to have a house with economic value. So it created a much different test for the grant of a variance, and it's a test that ZBAs struggle with. It doesn't mean that that you can't grant a variance unless a property would otherwise have no value. That would be a taking, a confiscation. That's not necessarily the standard. But so for example, if you had a building lot that was vacant, and vacant lots and lots with pre-existing conditions are really different animals. But if you had a lot that was vacant and was sort of configured in a way that no reasonable house could be built on it, no house that had any value could be built on it without a variance, then that would be a basis for the grant of a variance. If there was really no way to build a house on that lot that made sense. Now, somebody would say, well, I could build a 3-bedroom house, but I need a 5-bedroom house. I've got 4 kids. I need a 5-bedroom house. That doesn't meet the ENF test. It's not based on what the particular homeowner's needs are. And if a 3-bedroom house works on that lot and it's a viable option, then according to ENF, that's all you would be entitled to. So you couldn't get more than that based on ENF. So,
Oh, okay.
Go ahead,
I was
John.
gonna-
John?
No, it's me.
Peter,
Oh, all right, question, yeah.
yeah, quick question just on value. So let's take that same example. Is there a standard for, having economic value? So if on that same lot, you could only build a 1-bedroom home, but all the homes in the area are 3 or some sort of average. Does that play at all, or is it just the fact that you can build it all and it's going to have some value to somebody, then it's not a taking and you could deny the variance?
That's, John, that's kind of that's the $64,000 question, is where is the
question?
where is the line drawn?
Yeah.
I would argue that in a residential neighborhood in a town like New Canaan, a 1-bedroom house has no real economic value because the market for that is almost non-existent. In a single, a condo might be different, but in a house, a single family freestanding house with 1 bedroom has a very limited audience that would be interested in that kind of a house. And it could be argued that there's enough of a limitation that it would deprive the owner of reasonable use of the property and deprive them of any real value, even though, you could put a shed or a shack or a 1-bedroom house there, but that's not what the market is demanding, and it wouldn't have any real economic value. Now, there's there's a certain subjective analysis that's involved in that. But when the ZBA is rendering a decision, that's the kind of discussion that a court would want to see in a deliberation session. And if the board decided that, that deprives the owner of any real practical use of the property, that would be something that the board would have to agree on and would be one of the reasons to grant a variance. And it may very well withstand an appeal. But again, that's those questions are not black and white. There's not a cutoff. There's not it's got to equal X to be, no economic value. Courts don't decide that for us. They just sort of lay out the concept and then hope that ZBAs will make the right decision. Now, if some calls are easy. If it was a 4-bedroom house that could be built there, but the guy said, well, I need 5. Well, first of all, that's personal to that particular person and wouldn't justify a variance, and most likely. And in all likelihood, a 4-bedroom house would have economic value. There'd be a practical value to that house versus a 1-bedroom. Mm-hmm. What about a 2-bedroom? What about a 3-bedroom? I don't know. It depends on the fact situation, depends on the neighborhood, depends on a whole bunch of different factors, but it's going to be up to the board to make that ultimate finding as to whether or not a variance is necessary in order to allow someone to use their property the way it's intended to be used with an economic value to it, which is sort of in a way the minimum use that a property could be used for. So that's the hardest thing. That's the hardest sort of, deliberation and concept that the ZBA is going to have to look at, assuming the ZBA analyzes all of its decisions in accordance with E&F.
And that's the key issue. Can I just offer something? And I'm going to try to restate this in slightly different words. But I want to go back to before E&F. In those old days, more than 6 years old, you would look at an application and ask yourself, is there a hardship here? And we used to say, without any qualifications or whatever, that it had to be something attributable to the land, something between the land and the regulations. But you would look for such things as Pete said, well, on one side there's ledge, so you couldn't really build on that side where you had plenty of room. You had to build on the other side and go into the setback, or maybe there was too much wetlands, or maybe the lot was shaped in a strange way so that forced the homeowner to go into the setbacks too. So those are the things that justified hardship. And that was sometimes easy to see, in some cases, sometimes a little confusing. Keep in mind that it has to be something, still has to be something related to the property. Personal hardship is not adequate. Someone says, we're having triplets and we need all this extra space. That's a personal hardship. And obviously it can't be something decided by whether or not you like the applicant or they have a reputation for being difficult and you don't like them from town. It's nothing to do with the personalities or the people. It's something about the land. And in reality, in many towns, the percentage of applications that are granted is very high. I don't know exactly what your percentage is, New Canaan, but in many towns it could be 70 or 80% get granted. It's still to this day. So that's kind of how ZBA's looked at it before this case. Now, as Pete explained, you have this layer of economic value. I don't think we can overlook the other issues about configuration of the land, shape of the lot, wetlands, ledge, things of that nature. But this case did add this extra layer that it's not enough to say I've got ledge next to my house. Because now if you follow this ENF case, you then have to say, well, does the house, before any variance is granted, does it have economic value? So the example we give is it's a 3-bedroom house. They want another bedroom. Well, it has value as a 3-bedroom house, even though before ENF, let's assume, you would have said, okay, there's a hardship because you got ledge on one side. You have to go into the setback on the other side. Seem kind of easy. ENF says not so easy because the house still had economic value. The reality, however, so that's the law. The reality, however, is that I think ENF does not get evenly applied. I think sometimes it's ignored. I'm sure there are many ZBAs across the state that never heard of the case, even though it goes back to 2015. But it's out there and it's cited in other cases and it's still good Connecticut law. And it's something that has to be considered. So that's the dilemma that you face as a result of this case. And I told Lynn the other day when this case first came out, Pete and I were giving this the same kind of session to the Westport ZBA shortly after ENF came out. I mean, they were like angry at us for talking about this case. I mean, really, they were like, just couldn't believe it. And but that's been the law now for about 6 years. And that makes it difficult.
Ira, so back to John's original question. The most common application we get is there's an undersized lot, like with a pre-existing structure on it. Okay. So someone has a house, they buy a house, but they want to make it bigger for whatever reason. And the lot's, 1 acre, but it's in 2 acre zoning. Or they, buy the house, it doesn't have a garage, they want to add a garage to it. We get that a lot. Or they want to add a pool house to it. But someone buys a house usually, and then they want to expand on it somehow. My analysis that I wrote out a while ago, and I guess I'll go through just to make sure it's accurate still, is that the variance can only be granted when there's an exceptional difficulty or unusual hardship, and when applying the zoning ordinance to the specific parcel of land. So it has to be a unique hardship, which requires there to be a greater hardship and a different hardship from the restrictions imposed on the other properties in the area. So if the other lots are the same size in the area, it's probably not going to work. We saw this last month. Personal hardship, as you said, isn't grounds for it. And the variances are intended to prevent unconstitutional takings of the property. But Varela said that for there to be an unconstitutional taking, you essentially have to just take all the value of the property. But there's also the hardship test is the unconstitutional taking, and there's a unique hardship test. So the confiscation test looks at if there remains any reasonable use of the property. And if there's any reasonable use, then they have to look at the exceptional difficulty test, which is the one we always see. Because it's hard to imagine someone buys a house, and there's no value to it. So it's exceptional difficulty test. And under that, they have to establish that there's a unique factor of the property where literal enforcement of the zoning regulations would cause exceptional difficulty or unusual hardship. I guess that's what you're talking about now.
The exceptional difficulty has to be read with unusual hardship.
It's with
exceptional
difficulty.
difficulty. Exceptional difficulty is, quite frankly, sort of ignored most people.
Okay. So
Well, that's yeah. I mean, you're reading an accurate statement of the law, and then the question is, what do you do?
And then underneath that, that's where you'd look at the shape of the parcel, things like that, and you wouldn't count self-created hardship. When we get into the case we always see, which seems to be the undersized lot, where they had enough coverage, before, now they don't because zoning changed, something like that. Then we look at Vince versus Zoning Board of Appeals of Branford, which has said non-conforming uses should be abolished or reduced to conformity as quickly as the fair interest of the parties will permit. In no case shall they be allowed to increase, which is pretty high standard, which I guess we don't usually comply with because we allow them to increase. But so we don't just, so we'll usually grant the variance allowing them to increase. We're, I guess, in the 70% you mentioned before. Like you said before, if they're going to make it, sometimes we grant them because they're making it more conforming. That's very uncommon. So then we just come back to that literal enforcement of the zoning ordinance would cause exceptional difficulty or unique hardship, whether it's a pre-existing lot or not. Because that's a question we always seem to ponder. Is it's a pre-existing lot, so what do we do? And disadvantage in property value or income or both is not enough. It has to, so where does the line become? It doesn't have to be an absolute taking. There has to be some sort of unique hardship, but with, I guess this comes back to the question you started with.
Luke, I think maybe
Yeah,
there aren't two tests. There's only one test. The test is satisfied, you know, the economic value question is part of the test of whether or not there's a hardship. So that's part of the analysis. I can
And it
tell
makes
you
no
that-
difference. It makes no difference if the lot preceded zoning. At least that's my analysis.
Well, if the lot preceded zoning and it's non-conforming, it's
Correct.
entitled to exist. If it's empty, as I said before, if it's non-developed, it's going to get probably looked at in a little different manner because it's entitled as a building lot, even though it's non-conforming, to be developed. It may not be possible to develop that lot with a house that meets zoning requirements. It may not be possible. So in a case like that, a variance may be justified because the lot as a building lot won't have any economic value or won't have much because it's a building lot. So if you can't build on a building lot, you've taken away its economic value. So a variance in a case like that would be probably appropriate. In the case of an existing house on a non-conforming lot, and by non-conforming, I mean it's non-conforming not just the lot area. It doesn't really matter if the lot area is non-conforming. It matters if the house is non-conforming as to coverage or setbacks or height or something of that nature. If that house is non-conforming and it works as a house, then someone coming in and saying, you know, I got this, you know, I've got this smaller lot, so I'm over coverage. Well, E&F says, too bad. You've got a house, you've got economic value. You're using your property for what it's intended for. That's a single family house. The fact that it's a smaller lot, if there are, you know, unless that's absolutely unique in the zoning district, every, you know, lot conforms to zoning except maybe this one. That might constitute a unique situation, but otherwise, there's that. The fact that it's a smaller lot, the fact that it's shaped funny with an existing house on it is probably not going to justify legally a variance. And the point
because of E&F.
Yeah, per E&F. I think one of the points Ira was making is every ZBA that we're familiar with, first of all, if every ZBA followed E&F to the letter of the law, you'd never grant a variance. I mean,
instead of 70%, you know, I'm kind of making this up, but you'd be down at 5% or 10%
at most. Yeah.
And that's not. I'll be honest. I know we're on tape, but my observation is that that's not what a lot of ZBAs are doing. That doesn't make it right. If you're going to follow the law, E&F is the Supreme Court decision. If you're going to ignore E&F, then, you know, then a lot of boards do what they're going to do. But that's not the status of the law in Connecticut right now. So that's what we have to tell you. And
What
leave it
Pete
at that.
Gelderman said was my point. What Pete said was my point, that they're not entitled to make it bigger.
Yeah.
Not legally. Nope.
Keep in mind is it one of many smaller lots in the area because I got caught on that 24 years ago when I first became Westport town attorney, and I got handed a case already on appeal. And that was the issue. It was down by the beach area in Westport where all the lots are undersized. And the ZBA at the time granted a variance. And one of the reasons, or maybe the only reason, was that it was undersized. And the judge reversed that and said, no, I mean, it's not unique in that area. They're all undersized. So you do have to keep an eye on that too, as you mentioned.
John?
Let's assume that at the moment the house that's there is conforming. So take, for example, so let's say it was built in the 50s. And now what they want to do is build a second story or enlarge the second story, and subsequent zoning to avoid gloom has created this second story setback, right? And so we get a lot of times that the hardship is zoning has changed, right? When my house was built, I could do what I wanted to do now, but because zoning has changed in the interim, I now can't do something. And I've always questioned that as a hardship.
It's not a hardship. What the change in zoning did was create well, if they haven't added a second story, then it's still a conforming structure. If they had added it prior, then it becomes non-conforming. But to say that zoning has deprived me of a second story, it's the same test, John, ultimately. That property has utility as with one story on it. So it's ultimately the same story, the same kind of test. It's, well, okay, you'd like a second story. And maybe at some point in time, you could have had a second story. Now you need a variance. Now it's up to the ZBA to apply the correct test. And it's the same test that would be applied for anybody when it comes to a variance. So it's not a hardship because at one time they could have done something that they didn't do. And now they can't do it without a variance. That by itself doesn't justify a variance.
Okay, thank you.
We had a case once, and I can't remember exactly the entire scenario, but what stuck in my mind is that the applicant said that their hallways or they needed to expand maybe the top floor because it was an antique and the hallways were so narrow that they felt it was unsafe and that the firefighters could not get up the stairs. It became a fire hazard. To me, that would, I guess I should ask you, would that make the house something that would deprive them of, is that a hardship that it would become a financial hardship since they wouldn't technically be able to sell a house that is a fire hazard?
Remember, it's not financial hardship, Laura. Financial hardship is different than what we're talking about in terms of confiscation. But the answer to that is it would probably take more than someone saying they don't feel safe. It probably takes some expert opinion from a fire department saying this house is not safe. I think people are entitled to have a safe house. Now you're getting into a situation that's, that kind of argument's probably a little bit of hyperbole. I mean, it's, the hallway, I don't know too many houses that have been built where a firefighter can't fit down the hallway.
And presumably it got a CO when it was built.
Well,
so
it was an antique.
It's an older 1700 or 1800.
Oh, I see that. Okay, very good. Yeah.
You're kind of talking about something in the gray area there a little bit. It might justify it if in fact it was clear that people's lives were in danger if they couldn't widen the hallways, or the house had no value without the hallways being widened. I mean, again, that's tough. I mean, it probably does have value.
There are tough cases, and you'll hear other cases where it just seems, you'll say, this seems like the right thing to do here, and you'll have to make your call and balance all these cases and including ENF and, make a decision. But there are lawyers who are aware of all these cases and they do opposition work. And, we get this all the time. When there's an appeal of a ZBA, invariably it raises, ENF and Varela. These are the two cases. So that's what we confront when there's an appeal. If there's no appeal and nobody asks questions, then the homeowner is happy. So it's a tough. These are tough calls to make since these cases, they were tough before. Now they're even tougher.
So is the question if they denied any reasonable use?
Well, in a way, it's the question. It's whether or not it has economic value, as a house or as a whatever the
Well,
whatever it's zoned for.
before any variance is granted, is there economic value? That's basically what the ENF case was. It was a small house on a small lot, and they wanted to add a second story. I'm just reading some notes here, and the Supreme Court ultimately, I think they reversed the ZBA and said the house had economic value without the need for a variance.
Yeah, ENF IRA was actually it was a commercial property where they wanted to put a
Sorry,
second
that's
story.
yeah, no,
Yeah,
right. No, that's right. In Fairfield. Yeah, you're right.
yeah.
Right.
It would have the
That was
argument was they
right.
needed the storage to make the first floor viable as a
Yeah,
fast
he
food.
wanted to make it into a gourmet or into a good restaurant. That's what the quote
Fast
I
food,
took
yeah.
out of it.
But
And
my question is what's the economic value standard? Because you don't need a constitutional taking per se, which is zero economic value. Like at what point is it
It's not
considered
defined.
unreasonable?
It's not defined. So, I mean, it's just not defined.
So is it safe to assume that all pool and third car garage applications would become non-existent at this point, or we would not?
Well, I'm reluctant to tell you that you must turn down every pool application and every garage application and every, extra bedroom application, because people in town won't like that.
I mean, we get pools and that third bay on a garage quite often.
yeah, you have to look at that application and apply. Listen, the best thing you can do when you make a decision is to make sure you give valid reasons, good reasons to support whatever decision you're making, and also make sure that you have a collective statement of reasons, that everybody has agreed on the reasons. Now, that doesn't mean if you do that a variance that shouldn't have been granted is going to be upheld by a court. But it's important for a court to be able to see all that stuff. And look, just like a lot of ZBAs don't necessarily follow the strict guidelines of ENF, some trial court judges don't.
Yeah.
We've seen that. Now, if it gets up to the appellate court, they will. But even some trial courts look at something and say, it's now, again, if it goes to the trial court, that means that a variance that was granted has been challenged by somebody. And it becomes tough. And as Ira said, most variances are not challenged by anybody. So what the ZBA does in those, whether it would have been upheld or not, nobody will ever really know.
As long as you're applying the law carefully, as Pete just said, and your statement of reasons articulates why. There's something about the lot, it's narrow, it's funny shaped, or wetlands or ledge, or those are the classic things. And we can defend it, and you've explained it, and you've justified the reason for the hardship. Then if there's an appeal, we'll do the best we can with it. If they throw up ENF at us, we try to deal with it. As Pete just said, some lawyer, I said the lawyers invariably bring it up. That's actually not true. Some lawyers don't know about it. Some judges don't focus on it as much. So, apply the law, keep ENF in mind. but I don't want to take away here that, well, now they told us, the lawyers, that we can't grant anything. Because I'm not sure I don't think that's what other ZBAs are doing for their communities.
Well, so essentially you need a uniqueness to the lot, and then you need some unreasonable denial of use. Like there's two stages. Step one is you need something unique as to the lot, with the ledge, the topography, the wetland, something like that. Step two is you need the non-granting the variance to deny them reasonable use of it. Is that what you're
I'm
saying?
not sure. No, I don't know where the step two came from.
Because
step
E&F
one-
says that if you can make reasonable use of it, then it's not grounds
no,
for variance.
they use the phrase economic value. That's applying E&F strictly. Does it have economic value before the need for a variance? That's basically what it says. So that's what E&F says. But the prerequisite is they have to come in with some unique hardship, usually something attributable to the land.
So it's two steps. The first one's something unique to the land. The second is the economic.
Well, it's not so much a two-step analysis, Luke, as it is, those are the things that you're considering. I don't know that I would call it a two-step analysis. You don't have to, if you don't meet the first one, you can't get to the second one type thing. But
Well, if
generally,
you're not unique, I don't think you can get a variance. If everyone in the neighborhood has it, you're not getting a variance. It has to be
that's
something.
that's not the only test, though. That's part of that's just one of the factors in determining whether or not a variance should be granted. And sometimes it's not the shape of the lot or the size of the lot. It can be, there can be other factors involved with that too. So
Let's talk, so we don't run out of time, Pete, about a completely independent grounds for granting a variance. And that is reduction of nonconformities. You want to walk through that a little
Sure.
bit with the three cases that we always talk about?
yeah, they're I don't know, they're not in the outline per se, but there's Stancuna and Hescock, and I'll send you all copies of those cases if you'd like to read. And essentially what that simply says is that because, as Luke pointed out earlier, one of the purposes of zoning is to try to get rid of nonconformities as quickly as possible. If you have an application that will reduce nonconformities, existing nonconformities on a lot, then that can be an independent grounds for granting a variance, even in the absence of a hardship. It's not automatic. It's still up to the board to make a determination. Now, there's been some follow-up cases about this. And for example, the reduction in a nonconformity, let's say, let me give you an example of what I'm talking about. Let's say you have a house that is over coverage and you want to add a second story. And in exchange for adding that second story, you're going to get rid of part of your driveway and get rid of a garage that was encroaching into the setback. And you say, hey, if you let me have this second story, I'll get rid of this garage and I'll make my driveway, I'll make it smaller so it'll decrease total coverage on the lot. Courts have said that's not the kind of reduction in nonconformities they're talking about. It's got to be, it's not I'll trade you this for that. It's not a trade-off of a nonconformity here, but more conforming over here. It's not a de minimis reduction in nonconformity. It can't, it has to actually, and I'll give you an example of one that might work. If a town has a regulation that says you can't relocate a non-conforming structure on a lot, say the lot is non-conform, or the structure is non-conforming because it is too much coverage, and an applicant comes in and wants to relocate that building on another part of the lot, that's prohibited by the zoning regulations. But in doing so, the house will come out of a setback, where it was in a setback before. Now it comes out of the setback. It's being relocated on the lot, but you're eliminating a nonconformity that no longer would exist by the relocation of the house. That could be the grounds for the granting of a variance, because even though the house is being moved, you're eliminating a nonconformity. So it's not just a reduction in that case, it's an elimination of a nonconformity. So that sometimes can act, it doesn't happen very often where you see something where there's a reduction or an elimination of a nonconformity by virtue of the request for a variance. It has to, by definition, be a lot that's been developed, because you can't have a non-conforming structure on an undeveloped lot. So it's only coming in when there's a development, when there's a house, a structure on a lot, and there's some change that needs to be made, that if it's made will eliminate a non-conformity on that lot. You can say, okay, the benefit of eliminating a non-conformity is enough to grant a variance in this case, even though they haven't shown a hardship.
So let me just add, I know we're kind of dropping maybe a lot of stuff in terms and cases, and I get confused just listening to it myself. By the way, we are here to help. So if you have a particular application, Lynn knows how to find us pretty easily, and that's what we're here for. So sometimes there was a period where I felt after E&F where there was a flurry of these kinds of reduction of nonconformity applications, because it's independent of that case and everything in Varillo. It's just a different way to get a hardship. And some lawyers are saying they'd come to a ZBA and say, no, we're not talking about it. Nothing to do with E&F, has nothing to do. We're talking about, elimination of nonconformities, reduction of nonconformities, and here's the cases and all that. We're here to help. So if this sounds complicated with a lot of names, we can help. If you have an application, and just have Lynn call us and we could take a look and we can give you our 2 cents worth of advice. But there are, I think it's usually through a lawyer, lawyers that'll come up and say, no, I'm not talking about showing hardship here, just as Pete said. I have a different grounds that I'm asking you about, and this is what we're talking about here. And it doesn't come up that often, but it seemed like it was coming up a bit more before. Now it's kind of settled back, I guess. So that's just something to keep in the back of your mind. If you hear someone say that, you'll know that. Give us a call if you want, and we can help out. I'm not sure we can get too much farther than that. So I think we've dropped a lot of cases and terms, and I don't know if we made your job easier, more difficult, more complex, I guess, for sure. And the best thing, going back to the first part of our discussion, is keep these cases in mind, keep the E&F discussion in mind, and see where you go. I don't want you to walk out of here, as I said before, thinking, oh, we were just told we can't grant, any variance, or, 1 out of 100 or something like that. That's not quite what we're advocating, because I don't think that's going to work for most communities, such as New Canaan or anywhere. But these cases exist, and that's the latest from the Supreme Court.
And by the way, I know, John, you have a question, but I just wanted, before I forget, in response to E&F and cases like that, the Bar Association has been trying to put together a change in the statute that would define what the standards are for a variance and make it a little easier to determine. Now that process is easier said than done. It's got to go through the legislative process, and that may or may not, happen. But the Planning and Zoning section of the Connecticut Bar Association has been trying to come up with definitions that will clarify some of this stuff and maybe make the standards a little bit easier to apply, and make variances a little more readily available, perhaps. But again, that's something that may or may not happen in the immediate future. That's been in the works, Ira, for what?
Yeah, a few
5
years.
years.
Yeah, I think we got slowed down with COVID. The other thing I'll say, again, back on ENF, I mean, there are lawyers who will tell you, I mean, they're aware of ENF and they will say to you, we don't have economic value without a variance, and they'll make their argument. And it goes back to, I think, what Luke was saying before about, it's all relative. I mean, what is economic value? How low is low? Lawyers will make that argument. So you'll listen to what they say. I mean, the law is not crystal clear, I don't think, at this point. Judges look at it a bit differently. So it may not be quite as hopeless as it sounds at first glance. But that's the overview of the cases.
John, you had a question?
Yeah, it's a procedural question, following up on a comment you made about being sure that we're clear what the basis for the variance is. So it sounds as if just the record of our discussion is not enough, and that needs to be clearly stated in whatever motion is made.
Correct.
Yes.
Yeah,
absolutely.
the individual comments, cases have said this, it was in Varillo because I was rereading it today. Random comments by individual members don't constitute a collective statement of reasons. So your resolutions should be clear. I ran into this the hard way with another town where they would grant the variance, and the reason was one word: shape. And then I had a judge look at that later when someone contested and said, that's not enough of a reason. Or I don't even know what that means totally. I mean, we need more than that. And it forces the judge then to go search the record, we say, and go through the record and figure out what you really meant. And judges don't like to do that, and they shouldn't have to do that. So you do need to spell it out in full, in my opinion, full senses, so it's clear.
Okay.
And
in the resolution.
Yeah, and Laura, as the chair, you would say, or whoever the chair is would say, use those words. Does this resolution, constitute the board's collective basis and the collective thinking, collective read? If you have that language in there, makes it easier. Well, it makes it harder for a judge to say you didn't give your collective reasons, because what happens sometimes is a motion is made, and then someone explains why they think the motion should be granted, and other members, maybe say, yeah, I think that's a good idea, or they add something that, and maybe the board thinks, well, that's our collective statement of reasons, because the person who made the motion set forth a bunch of reasons, and we all said yes, but it isn't. It needs to be a little clearer than that. It also makes your defense of your decision easier for us.
And obviously that is the standard that we use that throughout here. Even if it comes to us, can we defend what you did? And if there's no appeal, of course, then no one questions it. But we go on the assumption that everything will be appealed potentially. And so that's the basis for these comments from Pete and me.
Well, it seems pretty easy to defend a denial of a variance. If you deny it, I mean, it'd be super hard for them to overturn. It's just the granting of variances you have
Right.
to appeal on.
Yeah.
That's right.
It's pretty rare that you see an appeal of a denial.
I don't know if I've ever read a one being overturned.
Yeah.
So let me, another procedural question, and then I'll shut up because I think I've exhausted everything I thought about. We had some discussion when we were going through, I think, Pete, when you were at our meetings, about once we go into deliberations, do we need a motion made first and then we have discussion, or do we have a discussion out of which a motion is made? Or is it just up to whomever, somebody to throw something out?
Yeah, I mean, there's nothing wrong with having a discussion prior to the motion being made, but a motion opens that motion up to discussion. So whatever motion is made then is discussed among the membership, but that doesn't mean you can't have discussion prior to somebody making a motion.
See,
Okay.
I like the discussion first, just to get a sense of where the board is at. And then somebody, having listened, some board members, says, well, I hear, it's unanimous to approve it or to deny it. And then you can make the proper motion. It gets confusing to me to, have like a motion or a motion to approve the application, and then that gets denied. So that's the motion to approve, denied. And, as opposed to a motion to approve, pass, or motion to deny, passed. So that's my thinking.
Thank you.
So as Ira said, we're always available. And, take advantage of that. If you,
Yeah, I mean, the best way, what we tell all commissions is work through Laura as the chair, and Lynn as your planner, and, ask for help. Always better to ask while the public hearing is open, is my advice too. Because if we have to say something, we'll say it, but it gives the applicant or someone else an opportunity to respond. We can certainly give advice during your work session, deliberation session, but if it's possible to ask for assistance while the hearing is open, I think that's safer also.
But one thing to be careful about is don't say, do you think we should grant this variance? Because that's your call,
Right.
not ours.
Yeah. That one we don't answer.
Yeah, we won't answer that.
Thank you very much. It's been very helpful.
Okay, everybody.
Okay, good. Call us when
Thank
you
you.
need us.
Thanks for
Okay.
attending.
Thank you.
All right.
Thank you all.
Good
Have a
night.
Good night. Good night.